Thank you very much for inviting me to come along and talk to you this evening. As Martin said, we will cover the first part, the changes to marriage registration, which is coming in very imminently on Tuesday. And if there is time at the end, then I'll cover some of the information on the changes to the marriage regulations for foreign nationals, which come into effect on the 1st of July of this year. So we'll if we can, we'll cover that as well. I think the first thing to say is that these changes that are coming into force affect all marriages taking place in England and Wales, not just Anglican weddings. So it's not the Church of England being singled out for special treatment. Every single wedding that takes place in England and Wales on or after the 4th of May will be affected by these changes. It's simply due primarily to the unique position of the Church of England and the Church in Wales in being able to issue our own marriage preliminaries. There are two complementary systems being introduced to ensure that all marriages in England and Wales are registered on a single digital electronic marriage register. In essence, the key thing to remember is that if you are conducting a marriage following the issue of ecclesiastical marriage preliminaries, so church marriage preliminaries, so that's banns by common marriage license or by a special marriage license, the marriage will be recorded on a marriage document, which the clergy are responsible for preparing and ensuring is accurate, signed, and what have you. But if the marriage you're conducting is being conducted following the issue of a civil marriage preliminary, which for the Church of England's perspective is primarily for marriages involving currently non-EEA nationals, where a civil marriage preliminary, so the superintendent registrar certificate, is required and has been required since March 2015, then that marriage will be recorded on a marriage schedule, which will come to you via the couple from the superintendent registrar who issued it, and it will be largely pre-populated with most of the information that is required. So that's the key thing to remember between the difference between a marriage document and a marriage schedule. So why are these changes being introduced? Well, the Bishop of St Albans sponsored a registration of marriage bill through the House of Lords, which was designed primarily to enable parties' mothers to be named as well as fathers on a marriage certificate, to correct what he described in his speech in the House of Lords introducing the bill, to correct a clear and historic injustice and this archaic practice unchanged since Victorian times, when children were seen as the father's property and little consideration was given to the mother's role in raising them. So that was the kind of primary focus behind the intended changes, simply to allow mothers' names to be recorded, which frankly is long overdue. That bill also provided for the creation of an electronic marriage register. Before that bill was able to pass into law, it got most of the way through Parliament, but before it passed into law, there was a case that went all the way to the Supreme Court. A couple called Steinfeld and Kaiden, who were an opposite-sex couple who didn't want to get married, but did want to have the benefit of a civil partnership. And so they took their case all the way through to the Supreme Court. And ultimately it was decided that because when the Same-Sex Marriage Act was passed in 2013, the Civil Partnership Act wasn't repealed, there was therefore an inequality of treatment of same-sex and opposite-sex couples, which was a breach of their human rights. So the government had to legislate to remedy that discrimination, and that legislation led to the passing on the 26th of March 2019, the Civil Partnerships, Marriages and Deaths Registration, etc. Act, which made provision around marriage registration and to provide for the extension of civil partnerships to couples of the opposite sex, and a couple of other provisions there, which are not really relevant for today's presentation. So we've had this this potential change now on the cards for a little over 2 years. The changes were originally hoped to come in around December 2019, but for various reasons that didn't happen. And then obviously we had the COVID pandemic, so that put things on hold again. But as time's gone on, I think that the Home Office Minister responsible for the legislation took the view that he or she couldn't delay the changes to permit mothers' names to go on marriage registers for very much longer. And so whilst the Church of England did make representations to prevent this coming in slap bang in the middle of Easter on the 1st of April, they have now come in at what is relatively short notice. So the regulations were laid in Parliament on the 26th of March, and obviously they come into effect, as we said, on Tuesday, on the 4th of May. These regulations make provision for the creation of that central digital marriage register, and then for the issue of marriage documents to record marriages by following ecclesiastical preliminaries, and for the marriage schedule to record civil marriage preliminaries as well. So that's kind of the background. So what in actual fact is changing? So with effect from Tuesday, the existing marriage registers are going to be withdrawn. So in due course, if you've not already, you will be hearing from your local superintendent registrar to make arrangements to call in your existing marriage registers. And I believe in Surrey, the process that the local registration officers are adopting is that they will be calling in both copies of your existing marriage registers, cancelling any unused entries in the register books, and then one copy of the register will be returned to you for the church's historic records. At the same time, any unused stock of marriage certificates will also be called in and withdrawn. So marriage certificates will no longer be available even for weddings that took place before the 4th of May. If couples need a duplicate of a certificate for a marriage which took place before the 4th of May, then the only place that they will be able to get that going forward will be from the Register Office. Similarly, from the 4th of May, marriage certificates for any weddings that take place anywhere in the country will no longer be issued by the clergy, or indeed by the authorised persons for any other denominations, any other faiths, or from civil venues. And in fact, I think that also extends to any marriages that take place in the Register Office itself. There will still be a 24-hour delay before a couple are able to obtain a copy of their marriage certificate. So this is not something which is just affecting the Church of England. If a couple are getting married anywhere, they will, from Tuesday onwards, not leave the marriage ceremony with a copy of their marriage certificate, as they have up to this point. So, as I said, the marriage document will replace marriage registers for the Church of England and Church in Wales marriages, which take place after an ecclesiastical preliminary, and that marriage schedule, which is issued for marriages after a civil preliminary, will be the method of recording those marriages. the marriage document or marriage schedule will continue to be signed by the couple, at least 2 witnesses, and the officiating priest in exactly the same way that the registers are currently. The marriage document will, however, only be a single document. It's not issued or prepared in duplicate, and it's not signed in duplicate. There is only, it is only required to be produced and signed as a single document. That marriage document or the marriage schedule will then need to be lodged at the registry office for the registration district where the wedding took place within 21 days of the wedding, either in person or by post. The regulations make provision for the possibility of future lodgement of that document electronically, but there is as yet no approved method of lodging that document electronically. So for the time being, it either needs to be taken and hand delivered to the register office or posted. The GRO in their Q&A sessions were very clear that there is no requirement that that document should be sent by anything other than first or even second class post. There's no requirement to send it by recorded delivery or registered post, and the GRO seem to be quite content that first class post is perfectly adequate. The officiating priest is responsible for ensuring that that document is lodged with the register office, but that task can be delegated to someone else. So that could be a parish administrator, it could be the couple, it could be the best man, it could be anybody else. But it is the officiating priest's responsibility to ensure that that happens. Once the document is lodged with the register office, the details will be added to that central digital marriage register, and within 24 hours of it being lodged, a copy of the marriage certificate will be available to be issued by the superintendent registrar at the request of the couple. And that's important. This is not something that will be automatically issued. The couple will need to request a copy of the marriage certificate from the registrar. So obviously, as the church is no longer issuing marriage certificates on or after the 4th of May, you can no longer charge for the issue of a marriage certificate. And actually the parochial fees order 2021 has been amended, and there is a new version which is available on the Church of England website, and that version should replace the version which should currently be up in all your parish churches with effect from Tuesday. So what else is changing? Well, because the marriage registers are being withdrawn, the Church of England and indeed the Church in Wales have decided that in place of that, so that there is still a record of the wedding held by the church, that there will be a new marriage service register book to be introduced, which is similar to the current baptism, confirmation, burial register books. The register is currently available for pre-order from Church House Publishing, and I'm told they should start being to be sent out from tomorrow. There is a requirement for a PCC to provide a copy of the marriage register book, and indeed the regulations requiring that were laid before Parliament this afternoon, and they come into force on the 4th of May. So there's a set of regulations called the Marriage Keeping of Records in Churches and Chapels Regulations 2021, which, as I said, were laid before Parliament today and come into force on Tuesday as well. And that is the statutory provision requiring a PCC to provide and for a priest to complete a marriage service register for the purposes of the church, and that contains pretty much all the same information as is contained in a marriage document. So what's not changing? So the main thing to say is that the legislation does not in any way affect the ecclesiastical marriage preliminaries. So bans, common licenses and archbishop's licenses will continue to be used and continue to be available on exactly the same basis that they currently are. It's just that if a wedding takes place after one of those preliminaries, it is recorded on a marriage document. Superintendent registrar certificates will essentially disappear, and they will be replaced by the marriage schedule, which is issued, although the application process for obtaining a superintendent registrar certificate or a marriage schedule will be exactly the same as it is currently. Qualifying connections and the like aren't changing either. And I think importantly, the status of the clergy is not changing as regard marriages. An Anglican clerk in holy orders will continue to be authorised to conduct a wedding without the requirement for the presence of a civil registrar or an authorised person being present. So by dint of ordination, you will continue to be authorised, legally authorised to create a marriage and officiate at a marriage and a legally binding marriage. The marriage itself comes into effect immediately that you make that declaration that the couple are now husband and wife. So that is the point at which the marriage becomes legally binding. The registration formalities confirm that, but that is, that the point at which the couple and therefore your authorization to conduct a wedding hasn't changed. The marriage service is not changing either, although signing of the marriage registers will in due course have to change to signing of the marriage record or marriage document or whatever, however that wants to be worded, which should be a slightly swifter process. So the choir will not have to sing Ave Maria quite so many times whilst that is happening. So when's it changing? As I've said, the changes come in on the 4th of May, so on Tuesday. So any wedding which takes place on or after that date must be recorded on a marriage document or a marriage schedule and not in the existing marriage registers. Okay, so the marriage document itself, the marriage document is an A4 document, and it is completed or prepared by or on behalf of the officiating priest whenever a marriage is authorised by bands, common licence or a special licence. Information was circulated last week, hopefully through your diocesan comms team or via your archdeacons, showing with details of how to obtain that marriage document. But in essence, there are 3 ways in which that can be obtained. First is from the clergy section of the Local Registration Services Association website, and there is on that a type and print version of the marriage document, which you can fill in online, print, and then have signed at the service. Or you can print off a blank PDF version of that document and fill it in manually in longhand, and again that would then be signed at the service. For any of you that make use of the Church of England's Life Events Diary application for keeping track of your occasional offices, all the information that is or has been updated so that all the information required to populate a marriage document is entered into it, and you can then print out a marriage document from through that portal, or failing that, hard copies of the documents will be available from the registration supplies service via that website, so registration.supplies@gro.gov.uk, and they will they will be able to supply a small supply, I'm told, of blank documents for your use. The marriage document itself contains all the information that the old marriage register used to, but it does provide for the ability to add up to 4 parents' names for each party. So mother, father, stepfather, stepmother, adoptive parents, birth parents, whatever. There is provision for up to 4 parents' names for each party to be included. There is provision for up to 6 witnesses to the marriage. The statutory minimum number of witnesses is 2, and I think the general recommendation is that 2 is perfectly adequate, but there is provision in the regulations for up to 6 witnesses. And the other slight change from the current marriage certificates is that in place of the age of the parties, their date of birth is now put in rather than their age. So yeah, there's no need to be calculating ages from dates of birth. The other thing to say about the marriage document is it does, at the top right hand corner, have a reference number. That reference number is a number which your parish is up to you to decide whatever reference you want to give the document, which works for you. I think that the suggestion is that you might, for any wedding that happens in 2021, you might want to preface it with 2021/1, 2, 3, 4, etc. But there is no requirement on that, and it's entirely up to you what you put in there. I would like to think that the superintendent registrar receiving marriage documents will kind of clock that, and so if he or she receives 2021 1, 2, 3, 6, 7, and 8, they may just contact you to discover where 4, 5, and 6 have got to. That may just be wishful thinking on my part. The marriage schedule, where that's necessary, so where a wedding is preceded by a civil marriage preliminary, will be issued pre-populated with all the required information, save I think probably for the witnesses' names, and that will be issued to a couple when they've needed a civil preliminary, and for the couple then to pass on to you as the officiating priest before the wedding, in exactly the same way that they are currently required to provide you with the copy of the superintendent registrar's certificate to evidence that you are authorised to conduct that wedding. So for I've clearly got my Welsh version has crept in here. So for the Church of England, I should say, this will primarily be when one or both of the couple is a foreign national. But the marriage schedule will be signed in exactly the same way as the marriage document is. The GRO guide for the clergy is, I think, has still not been updated, but they have committed to doing that before Tuesday. So that, if you're not familiar with it, is an extremely helpful guide on currently on how, amongst other things, to fill out the current marriage certificates, and that is being updated to provide guidance on how, amongst other things, to complete a marriage document. So that will be, I'm sure that will be an extremely helpful resource once that has been updated. I did check earlier today, and it still hasn't appeared yet, but it is, I'm told, on its way. Since March 2015, weddings involving a non-UK EEA or Swiss national had to take place using civil marriage preliminaries. So superintendent registrar certificate up to this point, unless a special license was necessary for other reasons. Banns and common licenses were not lawful. From the 1st of July, as a result of Brexit, that is changing, so that any non-UK or Irish national, except those who have got EU settled status or pre-settled status, will have to go through the civil preliminary route. So banns or common license will no longer be lawful for EEA, Swiss, or any other foreign nationals, unless they are an Irish national or have settled status or pre-settled status. The difference between those two is that if someone had, as at the 31st of December 2020, if someone had been resident in the UK for at least 5 years, they were eligible to apply for settled status. If they've been resident at that date for less than 5 years, then they can only apply for pre-settled status, but otherwise, effectively, there is little difference between those two statuses. A person who's got EUSS status, settled or pre-settled status, is required to provide evidence of that by obtaining a share code from the gov.uk website, which is listed there, so view-prove-immigration-status. Those codes are valid for 30 days and would need to be provided to you before or at an initial meeting with them, and you would then put the person's full name, their date of birth, and the share code into a status checker on the gov.uk website, and that will display a result which includes a photograph of the person, which will enable you to check whether in fact that person does indeed have settled or pre-settled status. So as is the case currently, evidence of their nationality, and because obviously I understand at the moment, ban or common licenses cannot be used for a non-UK EEA or Swiss national, and so from July onwards, that provision is extended, and so the only people that will be able to trade after the bans or common licenses are Irish nationals, people with settled status or pre-settled status. Usually, the is a valid passport. It's a straightforward way of someone's nationality. But if they have that, then there is a specified evidence checklist, Artisan Registry website, and I think also on the Faculty Office website, which we will be updating very shortly. From the 1st of July, an EU ID card is no longer deemed to be acceptable evidence of nationality. Basically, this will impact on qualifying connections only very slightly. As things stand at the moment, for a civil marriage preliminary, so a superintendent registrar's certificate, or what will become a marriage schedule, is only available to UK and EEA couples if they are resident in the parish or on the electoral roll, not if they only have a qualifying connection. Whereas if they are a non EEA, UK or Swiss national, if they have a qualifying connection to the parish, they are also entitled to be married after bans, because there is when the legislation came in, it was clear that if they would have been entitled to be married by bans before the 2nd of March 2015, they would would be entitled to a superintendent registrar certificate on any basis, on any similar basis after that date. So from the 1st of July 2021, that provision will continue to apply to all non-UK, Irish or EUSS nationals. The procedure, as I said, isn't changing, so they will have to give notice together and in person at a designated register office. Currently, the designated register offices in the Guildford Diocese area and surrounds are at Weybridge, Crawley, Winchester and Kingston upon Thames. From the 1st of July, because of the increase in number of people that will be requiring civil preliminaries, all register offices will become designated register offices. So the couples will be able to go to the register office of the registration district where they are resident. The sham marriage referral scheme, any application for a civil preliminary from a non-UK, Irish or EUSS settled status couples will be referred to the Home Office and may be investigated. The standard notice period for a civil preliminary is 28 days, but if it is investigated, that can be increased up to 70 days. So that timescale just needs to be borne in mind when discussing with couples the timing over when they should be considering applying for their or giving notice of their marriage. There are transitional provisions in place. Marriages involving an EEA Swiss national who hasn't got settled status or pre-settled status can still proceed after the 1st of July, but only if bans have been called on at least one Sunday before the 1st of July in at least one of the parishes where bans need to be called, or if the couple have given formal notice for the calling of bans in all the relevant parishes where bans would have been required to be called, and they have provided evidence before the 1st of July that they are UK, EEA or Swiss national. If a common license has been granted before the 1st of July, that marriage can continue regardless of whether it takes place before or after the 1st of July. And if an application for a common license has been made in writing but not formally determined, we don't actually use that process in Guildford, so that one really is not hugely relevant. If the affidavit for a common license has been sworn but the license itself actually hasn't physically been issued, again before 1st of July, that wedding can still take place, notwithstanding the new regulations. The changes don't affect the Archbishop's Faculty Office ability to issue special marriage licenses, and they will continue to be available to permit marriage of couples regardless of their nationality or immigration status. However, in accordance with the policy which we've had in place since March, we will not generally issue a special license in circumstances where another legal preliminary is available. So where the marriage is taking place in a Church of England, Church in Wales place of worship, which is licensed for marriages and in which the couple have the legal right to marry, the appropriate legal preliminary would be a civil marriage schedule. And we will not normally go behind that. The reasoning for that is that essentially the licenses that we issue obviously are in the name of the Archbishop of Canterbury, and we can't be seen to be going behind the will of Parliament as far as the issuing of licenses is concerned. We had to retain the ability to issue a special license because they are the only way that couples can get married in certain types of churches university school chapels, that sort of thing.